Hello, everybody. My name is Daryl Cartwright, and I'm an attorney in Birmingham, Alabama, practicing estate planning law, practicing throughout the state. Today, I wanted to give you a short video on do-it-yourself wills. Is it a good idea? Is it legal? Uh, First, let me give you a little story. This happened when I was just a young attorney many, many years ago. My firm that I was with had a particular client that we did a lot of work with, and uh, this particular client had officers that we often did estate planning for at very reduced rates. Let's just say that. And as one of the young guys there in this large firm, there were only a couple of us that were doing estate planning. I ended up getting a great deal of these low-cost estate plans that were done as a favor for the very, very good corporate client that we had. In any event, I had a client that the client called me one day and they said, "Hey, Daryl, I understand that y'all do estate planning for us at reduced costs." And I said, well, certainly we do. I'd be happy to help you. And he said, "Well, I have this situation where I actually have done my own will." Now, remember, this is, oh my goodness, I probably shouldn't admit it, but this is more than 25 years ago. And you didn't see the proliferation of the legal Zooms and things like that out there at the time. So it was a little bit surprising. And he told me that he had found a computer program, software program, and did the will on his own. And I said, well, that's fine. I said, let's do this. I said, fax over, I'm really showing my age now, but it was back in the days of fax versus email. I said, fax over a copy of that for me. Let me take a look at it before you come in, and then we'll sit down and we'll talk about it. And he said, okay, and he did, and came in the next day and sat down and we started talking about it. And I said, well, I've got good news for you. I said, you have a perfectly valid legal will in the state of Alabama. And he kind of bowed up. He was very, very pleased with himself. And I said, now, you did mean to disinherit your daughter and leave $1 to your wife, correct? And he just looked at me kind of crestfallen. He says, is that what I did? And I said, yeah, that's what you did. That's what the document did. What he did was try to follow questions outlined in that software program. And unfortunately, it didn't lead to the result that he wanted. He told me, tear that thing up. Let's get this thing fixed just as quickly as possible. And we did. We put in place an effective estate plan for him. Is it a valid will? Yes, that was a valid will in the state of Alabama. Now, would his spouse, for example, have some ability to challenge that? Well, yeah, there are things like an elective share and some family allowances and homestead allowances and things of that nature that could have done some things to help him in or help his family in that situation. And those kind of things I'll save for another video for another time. Suffice it to say that you are permitted to do your own will. I've had clients to ask me before, they said, hey, daddy died and or grandma died or whoever, and they hand wrote what they wanted to have happen after their death. Is that considered legal? Is that a valid will? And I said, well, let's look at it and see. Well, for a will to be valid, that's in the testator's handwriting, that's known as a holographic will. In some states, a holographic will is perfectly legal. In Alabama, a holographic will, one that's written entirely in the testator's handwriting, is legal, but only if it complies with our statute. Now, our will statute requires a will to be signed by the testator or someone at the testator's request and witnessed by at least 2 witnesses. Most wills are actually witnessed by 2 witnesses and a notary public because there's a special self-proved statute that really helps in the event a will needs to be probated. Again, that's for another video. But for purposes of this one, Any will must be signed by the testator and witnessed by at least 2 witnesses, including a holographic will, a will prepared entirely by the testator in their own handwriting. Now, a lot of attorneys will explain it that way, just like I did, and they'll leave it there. And that's not quite completely correct. There is one exception to what I'm telling you. Now, it doesn't come into play very often, and almost never does it help my client who has asked me that question about daddy's handwritten statement or grandma's will that she wrote by herself. But let's say that daddy came from a state in Idaho. I don't know what Idaho law is. Forgive me, any Idaho estate planning attorneys who happen to see this. If I am, I'm not saying it's your law. I'm just picking your state at random as an example. Let's pretend that Idaho has a holographic will exception that allows a holographic will to be valid, signed only by the testator. If daddy in that situation lived in Idaho at the time he signed that holographic will, he prepared that will and signed it, and then subsequently moved to the state of Alabama, Alabama would recognize that holographic will, unwitnessed by anyone, as valid, provided that the state of Idaho recognized it as valid at the time that it was executed. So I'd like to make that example as well. So can you do it? Yes. Is it a good idea? Maybe not. In my experience, you are seeking an attorney who practices in the area of estate planning, not just to prepare the document, but to give you legal advice concerning the document. Make sure that it complies with your wishes, make recommendations in certain situations, and then they put into place an effective estate plan that carries out your wishes in the way that best preserves your estate, saves money, and makes sure that your wishes are carried out. Hope you enjoyed this, and I'll see you next time.